Hi everyone, welcome back to SQE One Window, and that's the window from where we can have a bright picture of SQE One preparation, and we will try to talk about disclosure and inspection in it, and we will see that how it works. So imagine you are going into a court battle. Would you rather fight blindfolded or know what evidence your opponent has? Exactly. That is why disclosure exists. Disclosure is simply telling the other side that a document exists while inspection is letting them see it, usually by giving copies. The purpose is fairness. Everyone knows the evidence landscape, and surprises are minimized, and justice is more likely. So, MCQs often ask what is the difference between the disclosure and inspection. So both of them are totally two different things. You need to keep in mind. So you don't confuse both of these things as one. So disclosure isn't one-off event. In fast and multi-track cases, you should usually disclose after the case and cost management conference, the CCMC, but before expert or witness statement. So it can also be staged. For example, you might disclose document on liability first and only if the liability is proven. Disclose document on damages or quantum. Remember, the duty is ongoing. It goes on. If you find a new document after standard disclosure, you must disclose it immediately. Question can test your knowledge of ongoing duties and timing. Saying late discovery, disclosure obligation continues. You need to give it to other party. You need to just show it to other party. You need to show your cards to other party. So standard disclosure requires you to disclose document that support your case, damage your case or the other side's case, are required by practice directions like PD. So all of it, like once it is, if it comes under these umbrellas, you need to disclose them. Control is important. If you have it, had it, or could inspect it, you might need to disclose it, even if held by a third party like your accountant at that point. You can't say it was with my accountant, it was not with me, since you could have inspected it, you had knowledge of it, you need to disclose it to other party. And yes, a reasonable search is mandatory. The court considers complexity, number of documents, and significance. So in questions, scenario questions, for example, they ask like, does X document need to be disclosed? Think about support, adverse effect, and control. So these are three things you need to keep in mind. And once they come under these broader principles, you need to disclose that document to other party. So what counts a document? Documents are not just paper. They include emails, texts, databases, reports, photographs, plans, backup tapes, memory sticks, hard drives, all of it. Like if it is relevant to your case, you need to disclose them, all of them. So basically anything storing information, and don't forget electronic disclosure, e-disclosure comes with its own rules. So MCQs sometimes try to trick you by asking if a WhatsApp message counts. Yes, it's electronic evidence and you are bound to disclose it. So what is disclosure procedure in forms? The main form you need to know. Sometimes they ask it like, N265, disclosure statement and list of documents, N263, disclosure report for non-personal injury multi-track cases, 264, and 264 once again, electronic disclosure questionnaire. So, and 265 has three categories, different categories on that form. If you just, you can search it, you can have a look. Document open for inspection, documents objected to, state why you object to disclosure and inspection, document no longer under control, you need to give everything, be transparent in it. Who signs disclosure? The client, not the lawyer, except in certain cases. And beware, false disclosure is contempt of court. Very dangerous. So what is inspection? Inspection, after disclosure, the other party can inspect the document, usually by getting copies. You may refuse inspection if the document is privileged, disproportionate to the issue, no longer in your control. So these are three different things where you can refuse the inspection. If you refused, The other party can apply to the court using Form 244 and 244. Inspection refusal scenarios sometimes, of course, like, those are tested in SQE. So let's dig into it, So what is privilege? Privilege is your secret weapon. It allows you to withhold document from inspection, but you must still list them in the disclosure. Key type: legal advice privilege, that is between client and lawyer communication. Litigation privilege, dominant purpose in litigation. Without prejudice, genuine attempt to settle, like all those things which were genuine, you attempted to settle it. Common interest, shared interest with co-parties. Like, remember, privilege can be lost if you waive it or disclose publicly. If it is available publicly or you sent it, at that point you cannot claim privilege. So SQE loves to test the difference between advice versus litigation privilege and when privilege is lost at that point. And that's very, very important. So another thing is electronic disclosure. E-disclosure covers email, text, database, backups, and metadata, like everything that you got in electronic form. Parties should agree on reasonable scope before starting the search. Courts they balance reasonableness versus benefit. So form is N264. The electronic disclosure questionnaire helps the court understand what's required. Like, you should expect, like, in MCQs on which form are required. Like, sometimes they are, at some point they are not, like, but try to just make a list of it, like, to save your marks, like in exam, because everything counts. Sometimes you need disclosure before proceeding starts, called pre-action disclosure. During proceeding, you can ask for specific disclosure. The court can order disclosure of document relevant to your case or that may lead to a train of inquiry. Always try to request disclosure in writing first, explain why, and give at least it is 14 days for response. Only escalate to court if refused. So it is, like, tested in SQE 1 in dispute resolution when specific disclosure can be requested. So that's what you should keep it on your radar. So small claim, fast track, multi-track disclosure. Small claims only exchange document relied on with witness statement. Fast track or personal injury multi-track, standard disclosure using N265 by court direction. Non-PI multi-track, like personal injury multi-track, like it is DQs. N181 disclosure report is N263. EDQ electronic, we have all Doc 264, standard disclosure by N265. So that's what, like, I try to cover it, like, maybe it is an exam. So that's what it is. We need to understand sometime there is a memory test in SQE as well. So let's recap. Continuous duty of disclosure until end of proceeding. Accuracy is key. You need to understand the forms, identify privileged document correctly, that what is privileged and what is not. Inspection rules and challenge procedure. Electronic versus paper, small versus multi-track. That's what we have just said it. That's a bit different things. So disclosure shows it exists. Inspection lets them peek into it. Privilege locks it away. So that's what you need to keep in mind. Thank you very much for attending today, and I hope it helped. This is one of the area which will be tested in SQE in a couple of questions. If the examiner is sensible, they will not ask you about your memory test, your understanding. But I won't say nonsense, but there can be some questions which are like this. I have found like a couple of them. For example, one was from Law about register. Which register will record something in it? Thank you. Ta-da.